everyone. Welcome back to another episode of Divorce and Separation Coach podcast. Today, we're talking about how to finalize your divorce settlements when you've agreed them, do it yourself. And it's brilliant to see so many people choosing to do a DIY divorce and to try and negotiate their agreements among them because they're the people who need to actually agree to all of it. So it's great to see that trend. Nonetheless, we do find it quite difficult in a lot of cases to get things over the line. And there's a lot of services out there that help people at various stages, but that finalization of the agreements, making sure that they are actually valid and enforceable, is a technical part that's actually very important. And people at that stage are usually quite tired, not always in the mood to formalize things. So to talk about this topic, I've invited Rhiannon Compton. Rhiannon was a grade A family law solicitor, and she recently established a company called the Family Law Consultant. And what she does is she provides accessible and affordable legal services to the public, bringing, of course, all her experience for the industry and helping people in getting their agreements through to the courts and turned into orders. Thank you so much for joining me today, Rhiannon.
Thanks for having me, Chloe. I'm really, really pleased to be here talking about this real hot topic that we've got in the industry.
It really is. And I think, no-fault divorce was a wonderful change in our legislation. But it does bring along a certain degree of vulnerability for people who find agreements which probably work for them at that moment, but also don't really know what they're doing and need a bit of support. And even if you're able to agree what you want to do, there's always a point where it's helpful to have some support with the legal side of things. And so I wanted to kind of pick your brain, on that kind of bigger question of what people should do once they've reached an agreement, assuming they have a good enough relationship that they can have that chat, or even if they use a mediator, they have that conversation. What are the final steps to then make those agreements enforceable and legally binding?
Yeah, so there's kind of 2 points within this question. The first is the DIY divorce aspect, because that sits alone on its own and people can apply to the court on a portal to get divorced. But I think there's still this real misconception out there that the divorce will sever all of the financial ties, and it doesn't. So they can go through the DIY divorce process really easily, but that doesn't mean that they are protecting themselves in the future or kind of benefiting from that enforceability of any such financial agreement. So if they're doing their divorce themselves and amazingly, they're working so hard, I'm speaking with mediators, I know you're doing lots with people, when they're working so hard to reach agreements directly with so many different professionals, coaches, mediators, financial advisor, that they're working so hard to achieve that. If they're able to do that and reach an agreement, that's brilliant. But people don't realise that those agreements, as you've just said, are not enforceable and not binding until they get across the line. So the steps that they would need to take really is they need to liaise with a consultant or a solicitor or somebody who is qualified to draft that agreement into something that we call a final financial remedy order. And you'll hear people talk about that as a clean break order. You'll hear people use the term consent order. It all means the same thing. And I think that doesn't help, because I don't know about you, when I'm speaking with clients, they said something about a clean break. They said something about a consent order. What is it?
Confusing to people, absolutely.
Yeah, I completely get it. So the steps they would take is they'd get that advice and guidance on drafting, because the drafting is so, so important. I had somebody speaking to me only a few weeks ago who said, well, isn't it just a template? And I was explaining that a final financial remedy order, it is a template and it's set by the president of the family division, but it's a 94 paragraph template. It is very, very lengthy. And there are some clauses in there that you could have a stab at. We've agreed to divide the contents of the family home in accordance with the attached schedule. Okay, fine. But there are also really specific legislative clauses in there. They're the enforceable bit. They're the binding bit. They're what prevents the future claims. So that legal guidance on the drafting is really important.
Yeah.
So that's port number one for people: get in touch with a consultant or a solicitor or somebody qualified.
Yeah.
Once that is drawn up, then they need to sign it and they need to file it with the court, whether they're doing that themselves in a DIY approach, whether they are instructing that consultant or solicitor to file it for them. All of those kind of other options out there, because you have to file a few other forms, which we can come to, or we can maybe do a post about that if people need more information. So they can draft those forms themselves, they can instruct people to draft them. But eventually the aim is to get the consent order and 2 accompanying forms at least to the court, and a judge will look at it. Now, people often say to me, well, when the judge looks at it, what will they do?
Yeah, it's a good question.
Yeah, it's a great question. It's a great question. The judge's role when deliberating over whether to approve a consent order that's been filed by parties is to apply the relevant legislation. And I won't get into that in too much detail because it's a bit legalistic, but we have factors in law telling us how we should be dividing the matrimonial pot. So the judge will have a look at the financial position of both parties, the capital, their debts, their pensions, what they're earning, and they'll have a look at the agreement that they've reached and make sure that it isn't manifestly unfair.
That's actually a really good point, because a lot of people think that the court just rubber stamps it.
Yeah,
we've agreed. There's nothing up for debate anymore. But actually, it still needs to pass that final test and that review from the court.
It does. And I think it's been a really great kind of streamlining tactic, this DIY divorce, because people have become more amicable in terms of reaching a resolution, because they're starting off on no fault. They're kind of happy to continue with no fault. I think before the implementation of the DDSA, and you had to find fault, it didn't set the tone for negotiations.
Absolutely.
But because we've had this rise in people reaching their own settlements, judges are mindful that, you know, a couple of £1,000 out one way or the other isn't going to make any difference. A couple of tens of thousands of pounds on pensions, depending on the age of the parties, isn't necessarily going to make any difference. So they're not going to get into it to make sure it is totally 50-50, which I think some clients worry about. Yeah. Understandably. But if one person is leaving with, 70 to 80%, the other one is way down here, judges, rightly so, have a very important role that they don't allow those orders over the line. And quite often, I quite often advise clients, because one of the accompanying forms to go with that consent order is called a D81. And within that form, the parties have the opportunity to give narrative to the judge. Yeah. And that can be a really, really effective tool to preempt any questions the judge might have. So if they've agreed a slightly inequitable settlement, but let's say they're doing it because they know that husband is about to get £200,000 of inheritance and therefore doesn't need as much money from the sale of the marital home, you could outline that within the D81, and the judge is going to be much more minded to seal the order, make it binding, rather than question why husband doesn't look on the face of it like he's getting a lot. Yeah. So there is quite a lot of kind of steps to go through, but there are so many guides and professionals now. There's such great resources to help people get through them with ease. Yeah. But there's still a risk, I guess, if they choose to try and draft their own order, as you were saying, using a template. What I've seen happen with several clients is that they send it to the court and then it comes back. And so, because the judge doesn't understand it, because they haven't drafted the narrative properly, whatever it might be. And so then they have to review it, send it again. And it can take quite a bit of time. It can. And sometimes during that time, things evolve. And the agreement is no longer valid. And so it's a risky game, I guess, to try and do it all yourself, because it can lead to quite long delays, which then have an impact on your agreements, because they're not final until they've been signed off. Exactly that. I think we quite often in this industry see a trend of people reaching an agreement, but as you've just hit on, if there's then a delay, there's always a risk that agreement starts to unravel. Yeah. Because with the best will in the world, friends and family give well-meaning advice. and people look on Google, and throughout my years in practice, I've lost count of the number of times I've had clients say to me, well, my friend got divorced in 6 weeks. Because they've had really well-meaning advice trying to help and support them, but actually it's information overload, it's total overwhelm. And then they start to question, well, did I do the right thing? So and so.
Or they lose their job. I've had several clients who lost their job afterwards, soon afterwards. So suddenly everything's back on the table. So yes, things change quite fast.
They really can. They can. And I would really say to anybody who's thinking about drafting their own consent order, there are so many great services now offering that service on a really reasonable package price that it isn't worth taking the risk anymore in drafting it yourself. I think I can understand when it was kind of way back in the day when people were being quoted £5,000 plus, I can understand why they might take that risk, but we're not talking about that type of fee now. And it is such an important document that if you only get legal guidance or guidance from a professional at some point in your divorce, that is the time to invest in it. Yeah, absolutely.
Can you talk to us a little bit about the value of getting an order? So for those who might think, oh, well, actually, we can just agree among ourselves, and we don't need to do that final step. Maybe let's start with the financial order, and the child arrangement order is another matter.
Yeah. So that's a great question, Chloe, because that is a common point. People, you're coaching people who will say, well, we've agreed everything, it's okay. We don't need to get that drafted up. Why would we pay someone to do that? But those agreements, no matter how well meant they are when they're made, can really, really quickly unravel. And as we've already touched upon, circumstances change. So any agreement reached between parties verbally, even if they record it in writing, it's not binding and it's not enforceable in the future without those legislative clauses. And there's really, really famous case law, Vince and Wyatt, where a wife successfully claims against her husband something like, I'd have to check it, I think it's about 27 years after they divorce. 27 years! Because at the point that they separated, they both had nothing. So they were like, well, we got divorced and we've got nothing to share. So Mr. Vince then went off and established a multi-million-pound energy company.
Yeah.
Mrs. Wyatt said, well, hang on, because you've only been able to do that because I've been the primary carer of the children and facilitated you going off and doing all of that. Yeah. I'd quite like a slice of that, please. And not only is she successful in raising the claim in the first instance, she wins it. Yeah. And I think from memory, Mr. Vince has to pay her about £300,000 by way of a lump sum. And then he has to fund her legal fees, a further £300,000.
Yeah.
So he's spent over £600,000 27 years after they separated with nothing.
Yeah.
Who could believe that such a thing would happen? But that is what can happen. Now, of course, that is an extreme scenario. Very few of us, sadly, are going to go off and become multimillionaires. Very few of us are going to go off and win the lottery. Yeah. But it wouldn't be beyond the realms of possibility that someone does get inheritance received, or someone goes and gets a really substantial promotion within a proximate time frame to that agreement originally being made. Yeah. Or let's say it goes the other way and someone has some sort of catastrophic accident rendering them incapacitated. They can't work. Their income capacity drops to nothing, and potentially their capital needs increase because they might need adaptations at their home. So if you don't get that agreement formalised when you agree it, and formalised by way of filing it with the court, getting it sealed, then it's not formalised, it's not enforceable, and it's not binding, and it's all up for change. Yeah. And I want to be clear with all of our listeners here. I'm not saying that it would be changed. I'm not saying that automatically if someone has an accident, everything is back on the table and it's going to be totally stripped away and we're going to start from scratch. but I'm saying that could happen.
Yes.
That can happen.
And
The
it's not
law
a risk you want to be taking, you know.
Yeah, it's not a risk. So the benefit into doing it really is to protect your future self.
Yeah.
Because if you're agreeing with your ex or your separating partner, the parent of your children, that's great that you've reached an agreement, but can you guarantee you'll still be agreeing in a year, in 3 years, in 5 years? You can't. So getting that order formalized now is protecting your future self. And that's the way I always explain it to people.
Oh, you're absolutely right. And I think, you know, there's really two dimensions. There's formalizing the actual agreement in terms of how you're separating the assets and making that enforceable and binding. But then there's also that, I guess, that the legal financial separation that comes from it, that the clean break, which people assume are part of being divorced, because that's what you would think, right? We're divorced. Our finances are now separate.
Yeah.
So, you know, you may have nothing today and no assets to split, but you're still at risk for the future. And that's what people struggle with sometimes, because it's not very logical.
No,
you are divorced, but actually in terms of finances, you're not. And so that's a big risk to be taking.
That's exactly it. It's not logical, but also with the new DIY model, it's not outlined on the Gov website. You know, because the Gov website isn't there to provide advice.
Yes.
So it's not, when people are there clicking the button to say they want their final order of divorce, which lots of our listeners I think will still be thinking and referring to as decree absolute.
Yes.
So that everybody knows what we're talking about. Lots of people will be there clicking that they want that, but they're not aware of the ramification that isn't the clean break. And importantly, the Gov website can't tell them that.
And in your experience, what are the bits that people struggle with most when they try to draft their own orders and submit them themselves to the court?
I think generally speaking, what I find a lot of, and I completely understand this, is that clients have a tendency to kind of kitchen sink approach it.
Okay.
So they try to record every possible facet of the agreement within the final financial remedy order.
Yeah.
Now, orders are generally both broken down into lots of different categories. It is one document, but it's not all an order. So we have things like definitions, we have declarations, we have recordings and recitals, we have undertakings, and then we have the order.
Yeah.
I wouldn't in any way expect somebody who isn't legally trained in some way or works within this industry to know what the difference between all of those things are.
Of course.
So I very often find that clients will shove everything into the order portion because that seems like the most logical. I'm going to get this into an order. People keep saying I need a clean break order. But actually what they're then trying to do is make an agreement that they've reached enforceable by way of an order. And that particular part of the agreement possibly isn't enforceable.
Yes.
You know, like they've agreed that they will pay reasonable expenses towards a child's school trip. It's very difficult to find that within an order because reasonable is totally up for decision between different people, different parents, different schooling. Yeah. That level of reasonable is going to be different in each one of those scenarios. So that's a common one that I find. I also find a really common pitfall when clients try and draft them themselves is too much ambiguity, not enough definition. So they might say, you know, we've agreed that we're going to close the joint bank account, but we should really be defining that. Is there more than one? What's the account number? What are we going to do with it? Are we closing it completely? What are we doing with the balance? What are we doing if it's what if it's overdrawn? You know, who's going to fund that? So they're a bit too ambiguous and far too kind of vague in terms of what we're going to do if that breaks down. So
I see that a lot with parenting plans. You know, people say, "Oh, we'll split the holidays half and half."
Yeah.
Which holidays? Which week are you doing? A week each? Or are you doing a day each? You know, what does half and half mean? How does that work in practice?
That's it. It's a great intention. That's fantastic that they've reached that agreement, but it's just not. It's just too broad.
Yeah.
So I think that's where the expertise comes in terms of giving that responsibility to somebody else. I couldn't go and do lots of different things in other sectors and industries. We all have our skill set and our strengths. But I do find that happens a lot, and also a lot of ambiguity around timeframes. So and so has agreed to pay me a lump sum of £10,000.
I win.
When and then what happens if they don't? There's no, I wouldn't expect a lay client to know about inserting a default clause if that doesn't happen. So there's so much value in getting it done right, and there are so many pitfalls in not quite getting it right.
And improvising, especially something that is so important.
Yeah.
It really defines your financial health for many years to come.
Yeah.
It's very hard to vary after it's been agreed.
Hugely.
So it's very important to get it right, and it's worth that investment up front.
Oh, it is.
Can you tell us a little bit, Rhiannon, about your services? So how do you work with people? At what stage do you get involved? What kind of services do you offer in practice?
Yeah, so the platform was born really to try and bridge this gap between the average person on the street and legal services, because I, like you, Chloe, since this introduction of no-fault divorce, you've recognised the change in trends.
Yeah,
it's changed dramatically since that happened, and since the pandemic, all of those things, the cost of living crisis, family law trends are changing hugely. And that's fantastic, because actually what it's done is create an entire network of professionals that we maybe didn't really have pre-pandemic. Yeah. They were kind of very niche, whereas they're becoming much more mainstream now, which is brilliant. So I established it really to deal with the change in trends. And the services go from sort of very basic consultations, if I have people who just want to get a bit of a guide, bit of navigation in terms of the process, or they might want to know, kind of, for want of a better phrase, their rights. I get lots of people saying, do I have a right to claim against my husband? Am I entitled to my husband's pension? I bought this amount of money into their property. Am I entitled to get it back, etc.? So we do basic consultations where we just take on board the client objective, so what they want to focus on in that consultation. And interestingly, I will say to clients, if you are already sorted with your divorce, for example, you've done the DIY divorce bit, let's not waste time and money talking about the divorce procedure, because you've got that covered. So let's focus on what you do need, and let's really maximise the time and maximise what you're getting for your pounds.
Of course.
So we do those consultations, but then more so, we're getting lots of instructions now from clients who have either been within the mediation arena, or have been within the coaching arena, or have taken advice from a financial advisor and reached an agreement. And they are coming to us and saying, we've got the agreement, we need it drafting into something that we can send to the court. Absolutely fine. That's where our service is the most proactive in terms of what we're offering. We offer lots of things, but that's by far the thing that we get the most uptake on, because as we've just outlined, it's so crucial. Yeah. So clients can consult with us at any time. They can consult right early doors. I've just decided to leave. I want to know what the process is and my rights. What do I do with my children? All of those things. Or they can consult us halfway through mediation. This is what we're looking at agreeing. Does it sound okay? Based on the financial disclosure. Or they can come to us at the end when they've reached that agreement with the agreement. Now, I take lots and lots of clients from the mediation arena who have already got a memorandum of understanding. So our business model is to streamline this for clients, because it is stressful enough getting divorced. Yes, if we can take some of that and shoulder it, then that much better for them, and they're getting good quality for what they're spending. Yeah. So clients will quite often send us the memorandum of agreement and understanding, and that's what we'll use to formulate the first draft consent order. They'll send us the open financial statement from mediation, and that's what we'll use to prepare the D81, which is a form that has to accompany the consent order when you file it with the court. So we do all of those financial services within the divorce and financial remedy arena. Yeah. But we also have services in relation to Children Act matters.
I was going to ask you. Do you draft children arrangement orders?
We do. Yeah. We do. So we offer a parenting plan service, but as you've said now, with coaching and with mediation, there are some fantastic parenting plans coming out now that really it's a service that sometimes clients instruct us to do because we're already doing something else. And it's kind of like an add-on service. We already know the background. We've already got a relationship with them. But in terms of a standalone service, there are some really great resources out there people can access, on Google even. There's some really good content out there on parenting.
I mean, I've got a template for international long distance co-parents.
Fantastic.
There's a lot of templates out there. The tricky bit is
because that's a really tricky one.
It's negotiating.
Yeah. The international one, that's a complexity that you maybe need a bit of guidance on.
Yes, and hence the specialized support.
Yeah. So we do offer those services, but yes, our Children Act services are dictated mainly by child arrangements orders. So it works very similarly to the financial remedy orders and agreements. If people have reached an agreement, a routine for their children, and they want that drafting into something formal and enforceable, they can have it drafted into a child arrangements order, and that is sent to the court for sealing. Now, that is slightly different because it's governed by the Children Act 1989, and that piece of legislation tells us that we shouldn't have an order in place unless it is absolutely needed. And the actual wording is something along the lines of, unless it would be in the child's best interests to have one rather than not have one. So when clients meet us in the first instance, I'm really open with them about whether they actually do need this in an order.
I
because
have the same conversation.
Yeah.
And then are you really going to sue your spouse if they return the kids late every Saturday? So
and that's
if there's a real risk and a real concern, yes. But if it's just because you want a legal paper to document your arrangements, it might not be worth it.
Yeah, that's exactly it. So it's not for everybody. Not every separating parent will need that enforceability. Generally speaking, 15 minutes late here and there, no one's going to have an issue with. But if we're talking about really serious things like prohibited steps or, an agreement in relation to a holiday, an agreement in relation to sharing the school holidays and who's allowed to be around the children, those types of orders can be really crucial so that parents feel reassured in that when their children aren't with them, they're okay. We know what's happening with them. So we'll always have a chat to start with any clients, whatever the service they're looking at, to make sure that the service actually fits their objective and whether it's proportionate from a costs perspective for them. So we do those child arrangements orders too, and we'll talk about the different types of order with the client to make sure that is drafted really, really carefully, because as you say, and it goes back to this kind of structuring of orders, that it's not all an order, some of it's just recordings. Do we really need an order that, so-and-so will pack a packed lunch on a Friday, or whatever that might look like? But it's again, that tendency of clients to kitchen sink it. Yeah. Everything needs to be in there because you forgot to pack the apple for football practice last week. And I get it. I'm a parent. I get it. But also, it's just not an enforceable order.
And the other thing to keep in mind is that with children, inevitably things change.
Of course.
And so you can have an order, but all it takes is one of the two to move a bit further away, or the children to grow up, or to change schools, and it could all go pear-shaped, and you have to renegotiate it anyway. So you want to give yourself that flexibility, unless you really need the rigidity that the order brings.
Yeah. And I say often to clients, what you agree when the child is 5 will be redundant when you're dealing with a stroppy 14-year-old. Yeah. Because at that point, they are unlikely to care about mum or dad and just want to mess about with their friends and do whatever it is that teenagers are doing these days. I don't know anymore, but whatever it is they're doing.
TikTok, is it?
TikToks and all of those things. So that's exactly it. It's not always worth an enforceable order, but there are instances that they are so crucial to parents. So we can help with all of that. And also what we do within our Children Act services are statement drafting. So if somebody is in court proceedings, they will almost always be ordered to file a statement. Okay. That statement is so important. It's the biggest piece of evidence that you will file with the court, because it gives you the opportunity to really outline why you've made your application or why you're responding to the application, your rationale, any issues that you want to rely on. You can annex evidence to it, you know, photographs, text messages, etc. But again, clients sometimes, especially when they've been in a very acrimonious split, want to use that platform as and 10 years ago, he did this, and 5 years ago, he said that we weren't going to have turkey on Christmas Day, so I don't want my child to spend Christmas Day, that, etc. And they're issues that aren't relevant to the welfare of the child. So our service comes in to liaise with clients, work out what the message is they're trying to get across to the court, and pare that down into something that is strategically drafted. The other thing with the statements is you tend to only get 4 sides of A4. So you've really got to make them count. You know, getting into the background of why you separated and all the rest of it, unless it's a safeguarding issue, is not relevant. So that can be a really useful service, and we're dealing with, we've partnered up with some charities and things like that to kind of help clients within the court arena really strategize how they're going to get their evidence across. So that's our kind of Children Act services in a nutshell. But then we also offer services for people who have never been married or not been married in this relationship, cohabiting couples, whether that's the start of their cohabitation journey and they want to record who's bought what in, or how finances will be split and dealt with, you know, in the course of living, who's going to contribute to what. We can do all of that, and separation agreements if a cohabiting relationship has broken down. Just kind of recording what the parties' intentions were at the point, and recording who might have paid what and why it's been agreed at the end of the relationship. Now, I will say, so as to be completely transparent, that those separation agreements and those cohabitation agreements, they're not the same in terms of legal standing as a consent order. So certainly for our listeners, divorcing couples and separating couples who are not married are treated totally differently in law. And there is no such thing as common law marriage. That's exactly where I was going. You know, just correct that misconception. Yes. If there's one thing that you take away from this, remember that. But that's exactly it. So 30-year marriage, a 30-year relationship, upon the breakdown, treated totally differently. 2 different types of law, 2 different types of procedural rules, very different approaches. So within the divorce arena, that consent order, you want that to be binding and enforceable. Within the cohabitation arena, it won't be binding and enforceable, but it can be hugely persuasive. So if like something happens, a bit like very similar to a prenup, very similar. If something happens further down the line and somebody says, well, hang on, I've changed my mind, blah, blah, blah. One of you can rock up and say, well, actually, you said and signed with the benefit of legal advice that this is what you wanted to happen. So they can be really useful for people at the start and at the end of their cohabitation journey. Great. That's very helpful. Thank you so much, Rhiannon. I'm glad. And you know, I love to just chat. So I'm sure our listeners will have a good overview of the services now. No, but it's good for them to have to hear all this, but also to know that they can contact you if they have other questions, if they want to explore what that means for them. Absolutely. And I'll put your details in the episode description so people can reach you easily. Absolutely. And I always say to people, sorry, Clary, I always say to people, if there is something in particular that people want to know more about, if you're getting inquiries through the coaching and they're like, I'm not really sure, there's a common kind of theme. If people just drop me a DM on socials, email the website, whatever, we'll try and create some really good quality content to help you guys out, whether that's collaborating with other professionals, whether we're kind of all drawing on different sources. We want to give you as much information as possible so you guys can make informed decisions. So if there is anything, please do get in touch with one of us and we'll get our heads together and with other professionals that we work with to see if we can get some content out there that might help you. Oh, that's very helpful. Thank you for offering that. So just before we part ways, I'd love to hear, I like to do a little bit of a summary at the end of any podcast. Yeah. So for anybody or for couples, I guess, who've reached an agreement and want to, finalize and formalize that more what would be your top 3 tips? So I think tip number one would be to get in touch with a consultant or somebody in the legal industry who can get that drafted up properly for you. Make sure that it reflects the agreement and that it is binding and is enforceable, and you're protecting your future self. That's definitely tip number one. Tip number two is make sure that you really understand what that consent order is going to look like in practice when it's been fully implemented. Make sure that you've questioned everything you want to question, because you can't overturn them, not without a really, really good reason, which tends to only be a material non-disclosure. There are other reasons, but that's a discussion for another day. It's really difficult to sidestep them once they're sealed. So please make sure that you understand what that's going to look like for you once it's implemented. And tip number three, this is a bit of a procedural one, really. Get your financial disclosure sorted ASAP. Because without that financial disclosure, you can't get it across the line. Whether you're doing full Forms E, financial statements with mediators, or just that D81, which is a snapshot of your financial position, a judge won't seal it without knowing your financial position. So get your ducks in a row, get your disclosure sorted ASAP. In particular, as soon as you think, I'm going to want to negotiate a settlement, ask your pension provider for what's called a cash equivalent value. Ask for the pension details, because with some schemes, they're taking up to 16, 20 weeks just to give clients their own pension value. And also sometimes they charge you. Some of the public organisations charge you for that cash equivalent value. So ask for that ASAP, because what you don't want is to reach an agreement and then go, oh my gosh, I need my pension information. I didn't realise. And then you're waiting potentially 20 weeks, in which time that potentially unravels. So get your financial disclosure sorted. Get your financial disclosure sorted.
It's something I tell people in my book, Don't Screw Up Your Divorce, which is my new book, which is all about preparing for divorce. Start gathering that information early on. But also the reality is, how can you negotiate if you don't know what you're negotiating over?
100%.
It's very theoretical if it's on, preliminary numbers. And then if the actuals come in and they're completely different, well, they might completely, cancel and validate what you've agreed. So making sure that you have that information is really the first step before you can even have a discussion with your spouse.
Absolutely.
Brilliant. Well, thank you so much, Rhiannon. So much helpful information. And I'll once again put your contact details in the description.
Thank you.
People can reach out to you if they have any specific questions.
Yeah, absolutely. Get in touch with any questions. And thank you so much, Chloe, for having me. It's been really good to have a chat about this topic, and hopefully the listeners will find it useful.